mention, my lord, one unlisted matter of the original site, my lord. Here, my lord, I have filed an appeal against the tribunal's order, my lord, imposing huge cost, my lord, against me, my lord.
Why? What mistake the assessee did?
Lord, he did not appear before the appellate authority. That is the mistake, my lord. I have explained the reason, and the appellate authority, my lord, passed the order ex parte, my lord, without dealing by any of the grounds, my lord. Only short point, my lord, only.
You give, let us see, original site.
Original site, my lord.
Let me see.
Yes, yes. If it can be accommodated, I understand, my lord.
If time permits.
Yes, yes. It has not been
Lordship,
included.
can I have a leave to mention appellate side matter, Your Lordship? This matter was substantially heard by Your Lordship, and this was regarding Your Lordship had passed an order in division bench. Thereafter, the single bench had taken up the contempt matter. So we had taken the plea that the merger of the order.
Yes, ASG appeared.
Your Lordship. Any day, Your Lordship, because this was substantially heard, it will just take 10-15 minutes.
The problem is, Amrita, after we hear and conclude, I won't have time to dictate the judgment. As of now, only one judgment is pending, which is almost 80% complete. So I don't want to leave anything unfinished.
We'll bring our written notes of argument, Your Lordship.
But then you will complete and walk up. I have to do it. No? Let us see. You give the letter.
Since
My lord, very urgent matter. My lord, it was mentioned already. My lord, the Justice Ruby Kishan Kapoor, but that was not mentioned, not listed till today. My lord, the petitioner's husband of the petitioner, my lord, already died.
You give the letter to the OSD.
My lord, assign the matter.
No. You give the letter to OSD.
Grateful, my lord.
Yes, madam.
I had appeared before your streaming live online on 19th of May this year, and you had told me to file an appeal. It took me so many days to file the appeal, and the judgment has been very much when my life and living is at stake, sir.
You have filed the appeal?
I filed appeal and the judgment has come also on the 29th. But sir, no immediate relief given to me yet. And my life and living, I've got all CCTV footages, nothing was seen. So I was CCTV footages, videography, audiography, everything is with me, but none was seen by the court. And the court relied on what the others were saying. So my life is at risk, sir. If all my CCTVs are broken now, they can attack me anytime. It is my premises, my place. And I can't live. I live alone.
But any suit is pending? Civil title suit?
But that is going on for so many ages, sir. They don't appear there. They go on destroying my property. They are not appearing there.
But the division bench has passed a judgment. There are only two ways. Either if suppose there is any error which is apparent on the face of the judgment, review can be filed. Or you have to file an appeal to the Supreme Court. If you don't, if you want legal assistance, you go to the Secretary of the High Court Legal Services Committee. They will nominate a counsel and the matter can be referred
Sir, if they don't see my videos and my CCTVs, so she's going on breaking everything and no punishment for them. Doing all illegal works and all are recorded.
That is correct.
But nothing has been seen by the court.
But the court, see how court can adjudicate on all those disputes. That is why you have also proposed to install cameras. They also, private respondent also wanted to install cameras.
No.
So
the property is mine. How can they install cameras in my place? They can use the camera videography.
You file an appeal, madam. Sorry. Yes.
Sir, my life, what will happen, sir?
You can file an appeal to the Honorable Supreme Court.
Supreme Court, I can go at 72 to, I'm going to go to...
No. That is why we said you approach the High Court Legal Services Committee. They will advise you. The secretary is there.
So you told me to file appeal and I filed appeal. So this is what is coming out of it.
Yes.
My lord, I have a humble prayer before your honorable court. I'm Anushka De, a writ petitioner before the learned single bench and presently responded number 6 under the division bench in MAT 1023-2024. I had appointed Advocate Ashish Kumar Chaudhary as my legal representative. The legal proceedings were primarily overseen by my guardian and uncle, Mr. Abhijit Chaudhary, who had managed the entire process, including communications with my advocate. The case was initially presented under the division bench of Honorable Justice Debanshu Boshak, and thereafter the bench has changed on 4 occasions and is now currently under the division bench of Honorable Justice Shujoy Pal. On each occasion, the matter was listed for hearing. Proceedings have suffered delays due to the absence of counsel of all 3 parties involved. The matter was first listed for hearing on 31st July 2024, and the latest hearing date was given on 18th August 2025. However, in contempt of the orders of Honorable Justice Shujapal, my case was not listed on 18th August at all, and the matter was completely dismissed by my advocate. Due to these repeated delays in court proceedings, I have doubt about the efficiency of my legal representation, and uh, uh, also considering my current financial difficulties, I have resolved not to continue with the services of Advocate
That
Ashish
you
Kumar
can always
Chaudhary.
do. You don't
Ah,
require the permission of the
Yes, my lord, but actually, we had an agreement with the advocate that there will be a consolidated package. It was a verbal agreement of a consolidated package, of which 50% has already been paid during the proceedings. And now he is demanding an additional sum of rupees 1.5 lakhs to grant the NOC.
We can't be advising you on this, madam.
Uh, Actually,
I don't know how you enter into a consolidated package with an advocate.
that is, he had taken up my case during the single bench proceedings as well, and
Please ask somebody, they will advise you. We can't advise you what to do. But if you got a grievance against him, there are ways and means. There is a forum where you can go, which is in the City Civil Court building. It is up to you to consult somebody. Your grievance is primarily against your advocate. And what we find is this package business was not proper. As a client, you should not have it because it is purely a professional engagement. A client cannot, the advocate cannot identify with the client. He can't step into your shoes and become the litigant. So you are talking about some package, we don't know what is the other side of the story, but still you take some advice from somebody else. You are going to engage another advocate.
yes, sir. Like I
So
want to
therefore,
appoint.
you can take the advice of that advocate, saying that this has happened. How should I proceed? Okay,
Thank you.
please call.
Appellate side matter, item number 1.
And in this matter, my lord, I am for the review applicant, my lord.
What is the ground for review?
My lord, I will limit myself, my lord, only to the points of review only. I will not reopen the appeal, my lord. I am conscious of the fact. My lord, the matter is running under the heading to be mentioned. I am not sure because you are running under the heading application.
You could have filed an appeal to the Supreme Court.
My lord, at the
Sir,
many
you are a
things,
very
my lord.
big
Yes, certainly, my lord.
You are a very
Certainly.
big organization.
I could not prevail upon, to be very candid with this honorable court, I could not prevail upon my client so far the
So
appeal is concerned.
we will facilitate that. We will dismiss the
But
review.
since it is filed, may I just place the points only, my lord? Otherwise, my lord, my client would be
These are
prejudiced.
dismissal with exemplary cost, only to drag the matter.
My lord, I'll show only the I will only show the points of review only, my lord. I am conscious of the fact error apparent on the face of the record
All right, 2 points.
or discovery of new facts. I will limit myself to that 2 points only, my lord. Discovery of new documents, whether that has any bearing on this case or not, and my lord, whether there was any error apparent on the face of the record. I will limit myself. My lord is aware of that this particular case, my lord, the defense of my client was that the writ petitioner did not, my lord, file a single document in support of his claim. Whatever the claim was, my lord, with regard to certain letters sent to the, my lord, to my client FCI, claiming certain figures, that is 1 crore and 50 lakhs and odd. That was the very basis, and it was my primary defense, my lord. The no supporting document was attached. In course of hearing, my lord, my learned friend on behalf of the CWC relied upon one letter sent by the CWC, my lord, wherein, my lord, it appears that the CWC raised certain objection with regard to the recoveries that we have made.
Hmm.
My lord, the understanding between me and CWC was that, my lord, if certain recoveries is to be made, I will recover from the bill of the CWC and I will make the remaining payment. So that we have done. Since, my lord, the letter speaks of that the recoveries were protested by them, and we did not, my lord, raise any objection with regard thereto, therefore, my lord, relied upon this letter. So may I just place that letter only, my lord, because that is the foundation of this review application. If, my lord, kindly comes to the judgment, my lord, and that particular letter has been, my lord, reflected in the,
Page 92,
yes, my lord, just,
internal page 13.
yes, my lord.
We have got the memo of review. In that, the photocopy of the judgment is there.
Yes.
Internal page 13 of the judgment.
Yes,
standard
yes,
error.
my lord. So my the view of your lordship was that this particular letter speaks of certain figures, and if those figures are accumulated, taken into accumulation, then that figure is almost reaching to the amount claimed by the
1.45.
1.45. My humble submission is this, my lord, this letter does not speaks of 1.45. And that I will try to substantiate from this letter itself, my lord. Kindly comes to the very first line, subject to that letter, my lord.
Yes.
My lord, kindly see the letter one. Subject, recovery of 27,98,100 from the H&T, means handling and contracted bill of CW, C. Raninagar, for September and November 2012. So my first leg of contention is this, my lord. This letter does not speak of any other figure except that particular sum. And how it is, I am coming to the conclusion. I am now, my lord, reading the letter. It is observed from the H&T bills of rupees 63,22,822. That is the, my lord, total bill amount raised by the handling contractor. For the period of September and November 2012, your office settled payment of only 24,06,000 after making recovery of 27,98,000. So recovery is substantiated by 27,68,000. Thereafter, my lord, is taking into account the another figure that is appearing on fourth paragraph, my lord. Kindly comes to the fourth paragraph. In view of the above, it is requested to release the amount of 27,06,795 deducted on account of alleged DC and WC immediately, as CWC may not be in position to continue the acceptance facility in such situation. My lord, my humble submission is this particular figure is a repetition of 26,98,100 by some error or mistake on their part, my lord. It is mentioned at 27,06,705 because this letter does not speak of any, my lord, recoveries except that figure 27,98,100. So it is a repetition of that figure, but the figure is not matching. It is due to the mistake because this has never been explained that it is for some other period or for some other region. Now, my lord, kindly comes to the next paragraph. Incidentally, it is also to bring to kind notice that a sum of rupees 33.94 lakhs towards current undisputed storage charge bill, my lord, has taken into account this figure. My lord, in my humble submission, my lord, it speaks of itself. It is a 33 lakhs is the storage bill, my lord. Storage bill has no way connection with the claim made by the contractor. Contractor raises certain bills with the, my lord, the CWC. We made a, my lord, calculation. If any deduction is to be made, we deduct the amount. Thereafter, the remaining amount is released, and accordingly, it was released and deducted, or the withheld amount remains that they are, my lord, claiming. It will apparent from their letter as well. So this storage charge, my lord, cannot come in the, my lord, contention of the writ petitioner so far the deduction is concerned. Thereafter, and a further sum of rupees 56,67,000 towards the undisputed current H&T charges bill. So, my lord, it appears that 56,67,000 is the pending H&T bill, my lord. My lord, what happens once we make the deduction, immediately, my lord, the bill is released. So, unless and until bill is processed, my lord, deduction cannot be made. So, if the bill is pending, it appears, my lord, then the bill is not processed. So pending bill, we do not know the fate of this bill. I will come to the other documents to show what is the fate of this document. But so far this amount is concerned, my lord. This is a bill amount. It means, my lord, the amount is pending and the FCA has not processed.
Sorry to interrupt.
My lord.
All these submissions were not made We elaborately heard you. We
Yes,
elaborately
certainly, my lord. You elaborately heard.
patiently and
I can
elaborately heard.
certainly, my lord.
These are all grounds of appeal, not grounds of review.
My lord, these are
According to you, our reasoning is wrong. The interpretation of this document is wrong. This document, only 3 lines from this document we have taken, but what we have discussed about is what is the footnote in the page, in the next
yeah, next
page.
page. Yes, 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 my lord.
You
But my
file
lord,
an
my
appeal,
lord has
sir.
taken this figure only. The 3 and 4 figures, the total.
Sir, your organization is a pan-India organization. You have got all the wherewithal. You have got a team of lawyers. You file an appeal, test the correctness. If the Honorable Supreme Court says it is wrong, they will set aside the order.
Certainly, my lord. But since every review is there, my lord, in understanding, my, it is perhaps error apparent on the face of the record, my lord.
This review.
My lord, another ground, another. May I just place my? We have already filed it. Kindly allow me to take 5 minutes. I'll not reopen the appeal. I'm not reopening the appeal either, my lord.
Yes.
I'm not reopening the appeal in any case, my lord. If my lord kindly see the footnote also, my lord, the same figure has been repeated. This letters, my lord, limit itself to that particular figure 20. If my lord kindly say the next page, my lord. Copy 2, general manager, for kind information, that is sum of rupees 27,98,100 has been recovered. So therefore, my lord, this letter speaks of only this sum of money, and other sum of money relates to some other figure. And why I'm saying so, if my lord kindly comes to page number, because another letter that was also part of the writ petition, my lord. Yes, my lord. If my lord kindly comes to 95,
95.
their letter only, my CWC letter only. Here also, my lord, the previous letter that on which my lord has relied upon, that letter has been referred to. And my lord, the similar description has been made. Please refer to this office letter dated such and such, number such and such, dated 10/4/2013, the same letter, my lord, regarding recovery of 27,98,100. So in my humble submission, my lord, the letter on which basis, my lord, the total figure has been, my lord, calculated.
Next one.
95.
Next one.
Yes, I'm coming. So this letter, my lord, refers to that letter, my lord. And here also the similar amount has been referred to 27 lakh. So therefore, my lord, that letter was limited. So, but deduction is concerned, my lord. Recovery is concerned, because the claim of the writ petitioner was.
Therefore, our interpretation of the letter is wrong. Is wrong.
Yes, calculation of this. Yes.
This is wrong.
Yes.
So that is a ground for appeal. Please come. This review application has been filed by the Food Corporation of India, seeking to review the judgment and order dated 6/5/2025 in MATC 806 of 2024. The learned advocate appearing for the appellant would vehemently.
Well, there are certain new documents also that I could not place. Kindly refer to in the order, my lord, so that, my lord.
Yes, yes. The learned advocate appearing for the review applicant would vehemently contend that the court has referred to a letter of the Central Warehousing Corporation dated 10/4/2013 in paragraph 17 of the judgment, and given an interpretation as regards the amount payable, and the interpretation made by the court with regard to the said communication is incorrect, and the writ petitioner did not file any supporting documents in support of their claim, and the letter of CWC dated 10/4/2013 does not substantiate the total amount, and it is restricted only to recovery of rupees 27,98,100 and nothing more. Furthermore, it is submitted that in paragraph 4 of the said letter, the figure has been mentioned as 27,06,795, which is incorrect. Apart from that, in the paragraph 5 of the letter, certain figures have been mentioned which relate to storage fee, etc., which is in no way connected with the claim. Furthermore, the learned advocate has also referred to the letter written by CWC dated 3/1/2013 and submitted that there is a reference to the letter dated 10/4/2013 in the said letter, and in the said letter also the figure has been noted as rupees 2798,100. In our considered view, the grounds which have been canvassed in the review application are not grounds of review but grounds of appeal. Interpreting the communication, we have given our reasons as to why the writ petitioner would be entitled to the claim. And the finding recorded in the judgment is not confined to the letter dated 10/4/2013. It is settled legal position that a review application is not an appeal in disguise. Therefore, we are satisfied to hold that the review applicant has failed to point out any error apparent on the face of the judgment warranting exercise of review jurisdiction. Thus, for the above reasons.
Well, there are certain new documents also. My lord, kindly deal with it. Otherwise, my lord, I cannot perhaps agitate before the Supreme Court, my lord.
Next.
Deeply obliged.
Item number
3. CPAN 1056.
There was a direction to ensure that their proper police patrolling for allegation was illegal parking and all. It's a constant process, we are always doing necessary. The consciousness of the public is not there. That is the problem,
In fact, division bench has also noted that encroachment is there in front of KMC office. In fact,
Yes, my lord. I have a.
In fact, we had passed an order where
Yes,
Mr. Ghosh appeared.
This is a continuous process. My lord will kindly ask us to continue with the
This contempt
monitoring.
application has been filed, alleging disobedience of the order and direction dated order and direction made in WPA P 22 of 2025.
I have a report, my lord.
Dated 22/2025. The applicant would contend that in spite of the direction issued by this court to the officer in charge Southport Police Station to lock the wheels of the illegally parked vehicle and impose heavy fine and maintain strict vigil, action has not been taken by the police. Several difficulties faced on account of illegal parking have been highlighted in the contempt application. Mr. Chatterjee, learned advocate appearing for the state, has produced copy of the written instruction given by the officer in charge, Southport Police Station, dated 26/8/2025, wherein it has been stated that in compliance with the order passed by this court, the police have taken sustained measures to prevent illegal parking within its jurisdiction. Regular patrolling and checking are being carried out to identify vehicles parked in violation of the rules. In those cases, the wheels of such vehicles have been locked, compelling the owners to approach the police authorities for release, after which appropriate fine and legal action have been taken. Furthermore, it is stated that beat meetings are being conducted by the officers on regular basis, where local residents, shopkeepers, etc., are made aware that illegal parking not only disrupts normal vehicular movement, but also obstructs the movement of emergency services such as ambulances, fire brigades, etc. Further, it stated that during these meetings, awareness is created about the provisions of law relating to illegal parking, the penalties prescribed, and the consequences of repeated violation. Furthermore, it is stated that the police have undertaken sensitization drive using loudspeakers along the Kailash Road and other congested areas and warned that strict enforcement action would be taken against violators. Deployment of police personnel at vulnerable points have been made to maintain constant vigil and ensure smooth traffic flow. Further, it is stated that joint drive is also made with the Traffic Department of Kolkata Police for stricter enforcement and immediate response to complaints of illegal parking. Full stop. Proper signages have been installed at critical locations by the Traffic Department of Kolkata Police to discourage illegal parking. Furthermore, it is stated that the Kailash Road and other adjoining areas falling within the jurisdiction of the Southport Police Station are densely populated, so local people temporarily park their vehicles, but long-term parking is strictly prohibited. They undertake that the police station remains vigilant and proactive in addressing the grievances of citizens and ensuring smooth traffic movement in the mentioned areas. And constant monitoring and rapid response are prioritized to minimize inconvenience to both residents and commuters. Thus, from the report, it is seen that action has been taken pursuant to the direction issued by this court, which, according to the petitioner, is not satisfactory. It is in order to regulate, in order to curb illegal parking, constant and sustained effort is required to be taken by the concerned police. Apart from that, the mindset of the people is also very important.
Sure.
The concerned police may also involve the any local NGO which is operating in the area to sensitize the people and discourage them from illegally parking on both sides of the road, which would cause immense hardship to the commuters as well as to the traveling public. In our view, the matter shall be monitored by a superior officer in the rank of the Deputy Commissioner of Police Traffic Department, who is the third respondent here. The Deputy Commissioner of Police Traffic Department, Lal Bazar Street, is directed to ensure that sustained efforts are taken by the Southport Police Station to prevent the illegal parking. With the above observation, contempt application is disposed of.
We remain grateful. My lord.
Your Lordship, I appear on behalf of respondent number 5 and 6.
Taken on record, whatever it is. Next.
Item number 4.
Should I appear for the alleged contemner? Page 25 is the impugned order. Lord, unauthorized construction was alleged in the writ petition. Your Lordship directed the concerned PLRO to hear out everything and pass a reasoned order. That has been done, my lord. Page 9, my lord will find the reasoned order has been passed and communicated to the petitioner as well as the defaulting.
And who will give effect to that order?
Lord, it is the SDO in terms of the act. My lord will kindly come to the page 9 of this, my lord, where the observations are 1 and 2 are the observation, my lord.
And whether the ADM, DLLRO, Haura and executive engineer are they respondents in the contempt petition?
Excellent.
No.
Just a minute, my lord. They are not the contemner, my lord.
No, they are not the contemner, but they are the fourth respondent.
I follow. They were the respondent in the writ petition.
Fourth and eighth.
Yes, my lord.
This contempt application has been filed alleging disobedience of the order and direction issued in WPAP 94 of 2025, dated 2/8/2025. By the said order, this court had directed The Block Land and Land Reforms Officer, Domjur Haura, to fix a date of hearing in which the private respondent shall be directed to be present, including the president of the association, and after hearing the parties and perusing the documents, that they may produce a recent order be passed on merits and in accordance with law. A time frame was also fixed for compliance of the direction. The Chatterjee Learned Government Council has produced the written instructions given by the BLLRO, Domjur Haura, dated 28/2025, along with annexures, from which it is seen that after notice to all concerned, the BLLRO has passed a speaking order on 7/8/2025. Oh, no, sorry. 12/8/2025.
12
And no, 12/8/2025 and 15/7/2025. The copy of the 15/7 and 12/8. The BLLRO has directed the copy of the order to be sent to the ADM and DL and LRO Haura and the executive engineer Haura Highway Division, Public Works within bracket Door Road Department and the IC Domjo for necessary action. Since already order has been passed, the fourth respondent in the writ petition, namely the additional district magistrate and land revenue officer, Haura, as well as the eighth respondent in the writ petition, executive engineer, Haura Highway Division, Public Works within bracket Roads Department, is directed to implement the order passed by the BLLRO dated so and so, and give effect to the directions contained therein. The above direction shall be complied with by the said two authorities within a period of 12 weeks from the date of receipt of the server copy of this order. In the event the authorities require police assistance, the officer in charge, Domjur Police Station, is directed to deploy adequate police force so as to implement the directions issued by the BLL.
We remain grateful.
Next.
Clear.
Item number 5.
Yes, my lord, I appear on behalf of the petitioner. My lord, last occasion, pursuant to your lordship's direction, my lord, I have served upon the contemner as well as the
We are for the
learned advocates, my lord. My lord, the order passed by your lordship on 6th March 2025, that is at page 27. My lord, kindly see the paragraph, page 30, paragraph 2. Page 30, paragraph 2. My lord has got it. May I read, my lord? Insofar as the technical feasibility is concerned, we are assured that the railway administration has examined all aspects of the project. Nonetheless, endeavor the railways should be ensured the minimum extent of the water body is being utilized, and ways and means are to explore so that the water body can remain as it is. Technical feasibilities, including putting all pillars and laying down the overhead line, can also be considered. However, this is only the suggestion and not to the direction, and it is the expert who can take the proper decision. Now, my lord, it was traveled to Supreme Court. That is at page 57, my lord, if your lordship kindly sees. My lord knows, yes. Now, my lord, the paragraph 2, my lord, has to be considered. Till today, nothing has been done. And the review has been made. My lord has been pleased to dismiss the said review.
Pardon, sir? Your railway
For the railway.
Huh.
My lord, kindly see
আমাকে একটা copy দেবে?
second page.
one copy you
My
please
lord,
give.
railway also proposal has been given to the state government if the land will be given for the, they, railway will take steps for excavation of the extended portion of the pond. My lord, your lordship kindly take the second page of the report. The proposal of construction of embankment with 1 inch 1 into 4 mm box was not agreed by the Bhavadigi Bachao committee and other representative of local people
After details deliberation, railway proposes to construct 10 number of span of 24.4 m each 9 pillar composite grade viaduct bridge over the pond, which is the base suited as per the suggestion made by the Honorable High Court. Further, on date 18/6/2025, Secretary Bhabadigi Bachao Committee has written a letter to Railway wherein he has given putting up pillars and lying overhead lines, that is the construction of bridge, as one of the option of the resolution of the issue of Bhabadigi Pond. Trains are running from Tarokeshwar to Goghat as absolute block section and from Bishnupur to Moinapur as one train system only. The section from Moinapur to Jairambati is commissioned as one train system only in 24-25, and train running will start very soon. If the link between the Tarakeshwar Bishnupur is established, Eastern Railway will be able to run long distance mail express train, goods train, etc. towards Southeastern Railway through the route. Thereby, railway and people of West Bengal will be able to obtain the complete benefit of the project. Soil exploration has been completed. Tendering process for this viaduct bridge will be taken around 2-3 months. After finalization, it is expected to complete the work within 1 year if obstruction-free and agitation-free site will be provided by the government of West Bengal. My lord, thereafter, my lord, the correspondence was also held from the railway, my lord. Railway letter was given to the, my lord, the district magistrate Hooghly, and district magistrate Hooghly requested to the SP Rural Hooghly for providing the necessary police help. And my lord, the last letter, 2nd September, my lord, the SP Hooghly replied, my lord, that the meeting will be held, my lord, with the Bhabadigi Bachao Committee and other stakeholders, and my lord, the other state government officials. So, my lord, my humble and respectful submission is this: unless and until
The date has been fixed as 5th September. In
Yes,
the
my lord.
letter written by
lastly the second September letter.
that in the second page, last paragraph, this may be mentioned here that on 5/9/2025, a good number of officers and force will be deployed
Yes.
to perform law and order duty. You proceed further. Why are you not cooperating, sir?
No. We are cooperating all the time. If your lordship kindly have a
They took
look.
up the matter on appeal to Supreme
No,
Court.
my lord.
Honorable Supreme Court
Yes,
dismissed it.
yes.
It said that paragraph 2 suggestion may be taken in the right.
My lord.
Sir, it will 8 years it has been halted.
My lord, we are always cooperating. We are, my lord, still, my lord, we are willing to cooperate.
then
It is
you
our
do one
duty. If your lordship kindly have a look, my lord, this, my lord, this is a very short report. Eventually, lordship kindly come.
What is the date of the report?
My lord, this rate, my lord, this is the today I am filing this report. Today I am filing this report. All the, my lord, the current, my lord, the events, my lord, mentioned therein, my lord, that's like a list of date. Lordship need not go through that. My lord, kindly come to that, my lord, the last paragraph. একটা পাতা দিয়েছি, sorry. আমি দিচ্ছি তোমাকে তো নিশ্চয়ই দেবো।
All right, let us see what.
Now, my lord, kindly have a look. Now, my lord, after that, so, my lord, may I tell, because of this, my lord, constraint that whether, my lord, to what extent that pond is to be utilized. Now the railway agreed after so many, my lord, deliberations. They're very good after the pillar is to be put up, and then now we were never, my lord, that any, my lord, constraint from our side. But now eventually the railway said that on and from 5th the work will be progress, and please provide the necessary police or other administrative facilities. Now, my lord, the SP also, my lord, says, Lordship, kindly have a look. This is a letter dated from to 2nd September.
That is already
2nd September.
We have seen
Now
that
what?
letter.
Now, my lord, the police authority said after the, my lord, the DM's letter, DM said SP that to provide this. The SP said very good, no difficulty, but only the meeting is required because of the fact that to what extent to the deployment will be held and the, my lord, the time. Otherwise, no.
So among you,
Yes, there is no, there is.
even
Everybody is ready, my lord, to cooperate. Everybody.
ready only after the court order.
Yes. No, my lord, past chapter, my lord, let it be over. I am not on that, my lord. Let us today stand up on the today's
Second
event.
aspect which comes out from the Deputy Chief Engineer, Eastern Railways letter.
Because that, my lord, the Bhabadigi Bachao Committee, they, my lord.
Please.
My lord.
It will take at least a year to complete.
True.
If they say a year, it may take 2 years. So we are thinking of something which will the train will commence after 3 years from now. So you have to.
But let us hope that there will be no further, my lord,
We keep the
impediment,
we will
because
keep the-
administration, we have no, my lord, problem.
We will keep the contempt pending. We will record whatever is the submission.
Yes.
Let us see the progress. Probably we'll list the matter immediately after Puja. On that time, you
No difficulty.
give a,
No, no, no difficulty.
further
My lord, it is, I am very sorry to say, the conduct of the SP Hooghly Rural, my lord, they are sending letters saying, due to the Shravani Mela, due to the escorting the VIP duty, due to, my lord, the other, my
No,
lord,
no, no, no,
we
no.
are not able to providing
No, no,
the
no, no,
police.
no. My lord,
All
the
right.
Those
one
documents I have
or
also
two
annexed, my-
sentences should not be taken up in
Sorry
this
to
way.
say.
For the
No,
party.
no, sorry to say. SP said
The
that
report
we have to
was
take ready. Huh?
the Chief Engineer within
SP
bracket
report টা নেই
construction,
আমাদের কাছে।
Roman 2 Eastern
আমাকে
Railway,
রিপোর্টটা দাও
Howrah, dated
এসপি রিপোর্টটা ইয়ে রিপোর্টটা
22/8/2025
দাও এট লিস্ট
is taken on record.
ফাইল করা দরকার আছে।
The
করবো।
factual
ফেল
report
করতে
submitted
দাও একটু
by the district magistrate, no,
Yes.
by the
My lord, may I interrupt? Last page of the SP report. SP said all sorts of, my lord, the kindly have a look. All sorts of cooperation we are ready to. Last page of the SP report.
All right.
The earlier report that I filed of the DM, now the SP report.
the district
Last
magistrate Hooghly has
5
also
and 7, Lordship.
Page 5 and 7.
which is taken on record. The Superintendent
Assistance
Police
readily given.
Hooghly Rural Police District has filed a report dated 19/8/2025. The sum and substance of all these reports are that at last there appears to have been a consensus between the administration and the railways, and the project is likely to commence. Going by the report of the Eastern Railway dated 22/8/2025, if everything falls in place, the tendering process for the viaduct VIADUCT will take about 2 to 3 months, and after finalization of tender, it is expected to complete the work within 1 year. If obstruction fee and agitation free site will be provided by the government of West Bengal. The learned government council would submit that all full cooperation will be extended by the district administration as well as by the police administration of the Hooghly Rural Police District. And the 5th of September 2025 appears to be the date fixed on which deployment will be made. It is to be noted that the order and direction issued by this court in WPA number 13038 of 2017 dated 6/3/2025 was challenged before the Honorable Supreme Court by the Association for Protection of Democratic Rights and another in special leave to appeal C number 13023 of 2025. The special leave petition was dismissed by order dated 13/5/2025, and the Honorable Supreme Court made it clear that the suggestion made by this court in paragraph 2 of the judgment dated 6/3/2025 may be duly taken note of by the respondents. Therefore, there cannot be any obstruction or agitation by any of the members of the public or the members of the Association for Protection of Democratic Rights on and after the order passed by the Supreme Court, which was in an appeal filed by the said association. This fact should be taken note of by the Superintendent of Police, Hooghly Rural, and sufficient force should be deployed. The Superintendent of Police should also bear in mind that laying of the railway line is in public interest, and being an officer of the government, the authority should be proactive. The police authority should be proactive and ensure that the railways will be able to implement the project, forgetting about any interference that may come for while they exercise their powers and jurisdiction, either from politically affiliated persons or other busybodies. In case of such interference, the police authorities should take strict action against those persons and ensure that the work is commenced by the Eastern Railway at the earliest. In order to monitor the progress of the work, this contempt petition shall be, is adjourned. Um,
Time to take it.
to 17th November 2025, and on the said date, further report in the form of an affidavit be filed by the appropriate authority of the Railway Administration, the District Magistrate, and the Superintendent of Police, Howrah Rural Police District. List on 1711.
Malad, may I only pray? May I pray one thing? Malad, since Malad the three Malad the units or organizations, Malad railway, Malad the district administration, police authority. So let the railway be Malad directed to appoint a nodal officer who can Malad interact with all, so that Malad if they need
Can
this
be
communication.
discussed in a meeting. You don't require the assistance of the High Court, Mr. Sen.
No, but I think, Lordship, the railway authority be let them appoint a
Deputy
nodal
Chief
officer
Engineer is
who
there.
will interact with the DM
Yes,
or
yes,
police
sir.
authority.
Sir, please let their officers, let them first bear in mind public interest. They are
Malab,
here.
that is why Malab, I say because of the
DM,
fact.
DM Hooghly, I know personally,
My-
very proactive officer.
My lord,
No problem.
my lord.
SP Rural also will do. But there is some political interference. We are able to read in between the lines.
Well,
That
I
is
think
what prompted us to make that observation.
I think now there will not be any problem. I think Malab, after my lord's order.
Kindly recorded one thing, the DRM of the Eastern Railway Howrah Division has been changed. And my lord, the new DRM is my lord that the Vishal Kapur, my lord.
Since the divisional railway manager of Eastern Railway has changed and a new officer has taken charge, we grant liberty to the learned advocate for the applicant to suitably correct the cost taken
Vishal Kapur.
and wherever required.
And Malab, instead of SP Howrah, it has been gone down. It should be SP Hooghly.
Sorry.
I have to.
Get pullers. Get.
And my lord,
Next.
new DRM is the Vishal Kapur, my lord.
You give the
বলে
name,
দিয়েছে
give-
বলে দিয়েছে
Next, next.
I am
Yes.
ready.
Item number 6.
And we requested Mr. Sen to appear in this matter.
My-
You have received papers,
Malab, I have received.
instructions you have got,
Malab, I have received the paper, but
because you have got a very tough opponent.
that is true. And my lord, only thing may I tell, my lord, that only thing may I tell, my lord, the preliminary talk may I tell. My lord, in this way, my lord, in review petition, my lord, the scope of the read petition and the issue all are, my lord, going to be, my lord, expand in this way, where, my lord, first of all, my lord, the scope
All
of
right, we will hear you, subject to you have got instruction
My lord.
from your client, you get written
My
instruction
lord.
on whatever the grounds. Please, because Mr. Chakravarti is very objecting to producing some OC's letter,
Yes.
etc., without an affidavit. It is better that you get an affidavit from your client
My-
Yes, that will be
my,
fine.
my,
to save your client from
my,
Mr.
my,
Chakravarti.
my lord, get
Challenging your lordship's order, my lord, and SLP has been filed that has been dismissed, my lord.
Oh.
That has not been brought to your knowledge, my lord. Now, every other day, my lord, a paper has been furnished before your honor, my lord, your lordship. Without an
That's
affidavit.
because but that's because the review is either pending, because even assuming SLP is dismissed in limine, that doesn't mean that the court should not hear the application on merit.
No, it is not a
Has
non-speaking
been-
order. It says we do not find any cases made out.
Yes,
for
yes, that's
interference.
right.
So reasons have been
Reason
given.
there.
Doctrine of merger.
No, my lord. Even reason is there. Even his reason is there. According to court's judgment, even reason is there. The court has to hear the application on merit. I will satisfy your lordship. Because the larger court asked me whether you have filed a review petition or not. Justice Bindal asked me. Yes, I filed a review petition. And that is this, that's why.
But not,
It is not a-
normally one line will be say that liberty is granted to the.
No,
petitioner
in
to pursue the-
SLP it is not required. I will satisfy your lordship. I will satisfy your lordship.
Then you first you get over this preliminary.
Yes, my lord, no problem. Tomorrow you fix it.
Um, as against the
There's a merger.
final judgment dated
No, merger, not
2025 in MAT 240 of 2025. The review applicant had filed an appeal to the Honorable Supreme Court in special leave to appeal C number 17378 of 2025, which has been dismissed by order dated 8/8/2025 by observing that no case is made out for interference with the order passed by this court.
It's a case of merger. No.
Okay.
It's a base of
In the light of the order passed by the Honorable Supreme Court, the review applicant has to first satisfy this court
tomorrow if he's
that this review application is maintainable. In the light of the fact that reasons have been assigned by the Honorable Supreme Court in the order dated 8/8/2025, and prima facie we are of the view that doctrine of merger would apply and the review application is not maintainable. Mr. Chakravarti, learned advocate appearing for the review applicant, agrees to make submissions on this issue. List next one.
well, tomorrow if he's tomorrow. Well, because this point is already decided by the Supreme Court, latest decision is there.
That is why we are granting.
My lord, this is not a merger. How could it be? No, because it is already settled.
All right, Mr. Sen.
My lord, it's already settled.
In the meantime, the learned advocate, Mr. Sen, learned advocate appearing for the state, shall get written instructions from his client, and the same shall be as client in the form of by submitting a report which shall be filed in the form of an affidavit.
Yes, madam.
You are for the private respondent. The private respondent is also granted liberty to file their affidavit. In that you raise the preliminary objection.
My lord, already Kunnaswamy's case, code is it is the Supreme Court, even on reasoned order passed by the Supreme Court, the review should be hard on merit. But this is, I don't know, this is too late to ask this question.
I don't know, sir.
Well, I can show you.
Well, after long vacation.
After long vacation?
After vacation. Next.
Get.
My lord, because, my lord, one judgment, the petitioner, my lord, is 90 years old. And it is
immediately after vacation.
Immediately. Well, why? Because 10 years, last 5 years construction is stopped. Because it's the government land, 3 years, within 3 years it is not completed, the government will recover, resume the land.
All right, we'll hear. Next.
Item number 7.
This is my
In item number 7, I beg to appear on
I am
state.
for the response.
My lord, but I have a
Kindly
preliminary objection to the text and
My
let
lord,
him submit, I will.
Let me submit. My lord, kindly come to page 54, Lordship's order. Relevant portion is paragraph 6 and 7 of your Lordship's order. Challenging the single judge order, my lord, this has been preferred regarding the place of holding Durga Puja, and your lordship was pleased to observe without disturbing my business and business place that will be observed, and it is restricted to the year of 2024. That is his paragraph 6 and 7. Then, my lord, my learned friend representing the my lord private respondent, my lord, come with an application for clarification. The order passed in page 58. Relevant portion is para 5 and para 6.
Yes.
May I please? Paragraph 4, my lord. Kindly have a look.
না কেন বলছিস এত বলতে দে না ওকে
তোরা দুজনে একসাথে আছিস তো অসুবিধা
আমি আলাদা আছি
Learned advocate appearing for the writ petitioner on instruction submits that the petitioner appellant is not objecting to the to the conduct of the puja, but under the guise of conducting the puja, his business activity should not be hampered. And next, from the photographs which have been filed along with the application, their application more particularly page such and such, it prima facie appears that there cannot be any obstruction to the writ petitioner appellant from carrying out his business activities in the shop room, godown, etc. Since the writ petitioner appellant has stated before this court that he will not object to the conduct of the puja for the year 2025, the said submission is placed on record and the writ petitioner appellant shall not object to conduct the Durga Puja. Likewise, the applicant herein also should ensure that the business activities of the petitioner appellant which is being conducted from a sub-room godown should not be affected in any manner. In that event, there is any other difficulty which may be faced by the writ petitioner appellant or the applicant herein, they are directed to approach the officer in charge, Salboni Police Station, District Paschim Midnapur, so that the matter can be resolved. Now, my lord, I pause for a moment and my lord kindly come to page, my lord, the page, my lord, single bench. My lord, kindly come to page first, 39. Page 39. There is a suit where I am obtaining an injunction, and page 39 is the, my lord, I am reflecting the suit property. That is my shop room or godown where from I am running my business. And this has been, my lord, there is an injunction not to disturb my possession. There is, my lord, also annexed here. Now, my lord, what happened after the last order which I have been placed before your lordship, the order has not been uploaded. They, in connivance with the police, they took possession of my shop room by violating the order, by misinterpreting the order passed by your lordship. My lord, I made an application.
How do you say that the order has not been uploaded?
Not been uploaded on that day. They are taking possession. Not been uploaded in the official website.
Something very wild allegation has been.
No. This is the fact. I am.
No. You are making an allegation.
No. I am not making allegation.
You are making an allegation against the court and the department.
No.
Please establish.
I am not making any allegation. Yes, sir.
You are trying to make mischief, misuse the order. Now, what is you have filed a CAN application 3.
Yes. Kindly come to page 65. One of the English, one of the yes, that is written here.
No. You don't want the puja to be conducted. That's all.
No, they are at the Garba Puja. They are, my lord, grab my property.
It's a separate cause of action. Don't raise the voice. We can also raise the voice.
No, my lord, I am not raising my voice. I am only demonstrating what has been happening. My lord, what I am trying to submit, I am not making any allegation. I am submitting that, my lord, since the order just passed, on the very next day, when the order has not been uploaded in your official website, they, in connivance with the police at the Garba Puja, they took possession of my shop room. This is my submission. Yes, my lord, kindly see my page 65, my presentation allegation.
Application has been filed by the appellant in FMA 137 of 2025.
Friday order was passed, Saturday and Sunday, but there is not uploaded. In that maybe they have done so.
The applicant in CAN 2 of 2025 has misused the order dated 4/7/2025 and taken forceful possession of the applicant's shop room. In this regard, in this application, namely CAN 3 of 2025, the applicant prays for an order of clarification or modification of the order dated 4/7/2025 and to frame a guideline that the applicant can perform Durga Puja for the subsequent years without disturbing the peaceful possession of the petitioner or the godown comprised within Mausa so and so, page 16 of the application service. In our considered view, if according to the petitioner, the shop room has been illegally taken over, it is a separate cause of action. And while disposing of CAN 2 of 2025, we had recorded the submission.
Paragraph 4.
Made on behalf of
Paragraph 5 and 6.
It starts from paragraph 4 onwards.
Made on behalf of the writ petitioner / appellant that he will not object to the conduct of the puja for the year 2025. And this submission was placed on record. Therefore, if anything has occurred which according to the petitioner has affected his interest, it will be well open to the petitioner to avail appropriate remedies before the appropriate forum in accordance with law. And accordingly, the application stands disposed of. No further application shall be entertained in this appeal at the instance of any of the parties. Next.
Obliged.
I'm grateful, Mila.
Item number 8.
It is my application.
Lordship, item number 8, Mr. Kanodia is appearing. Your Lordship is on legs in another court. Your Lordship may kindly keep it for tomorrow.
When do you want it?
Tomorrow, Your Lordship.
What is the review?
That's a very small point. May I just
You can manage.
Your Lordship, in that case, a small password, Your Lordship.
Kindly, my lord. Well, this matters where, my lord, dismantling of single properties, my lord had delivered 3 judgments in 3 matters, where the department ought to have paid the tax component and thereafter it had to be reimbursed to the service tax department. But that part has been complied with. Their further allegation was that there was further recovery by the state GST on the same issue. And that was asked to be refunded to the electronic credit ledger. But after the order was passed, because in the original writ petition, we were not parties, my lord, because after division bench, my lord had made us a party. We find, my lord, challenging the show cause for the same period, there was an earlier writ petition where this very issue was there, where my lord was pleased to stay the proceedings because there is a 20% they have deposited. Today, this 65 lakhs, which has been, lordships have allowed this, basically modifies the orders of my lord, which was passed previously. This
that appeal is still pending?
No, appeal disposed of. Appeal disposed of, writ petition filed when they had challenged the jurisdiction of the authority concerned, saying that the Bureau of...
assuming they withdraw the writ petition.
They have not, they have challenged that demand remains. So demand 20%, 65 lakhs is part of that 25.
All right, tomorrow.
Grateful to you.
This is one matter, I will try to. Yesterday I did not object. This matter, this matter,
Yes. We'll hear you tonight. Don't worry. Next.
Lordship, we are missing lordship. So
next.
Item number 9.
May I submit my for the respondent led by Mr. Bhattacharya, Mr. Online.
Yes.
Yes. This is for recording of my submissions, my lord. In para 2, page 2, para 2, left side is the submissions that has been recorded, and the right side, the submissions I am begging to pray to be recorded. These submissions I am begging to pray to be recorded, my lord. So the first submission is, the employer gave no objection to petitioners filing fresh writ application, the instant writ application, my lord, WPA 22944 of 2022 in place of WPA 7832 of 2020. Order dated 23/9/2022. It is in the file, my lord. This order dated 23, it is in can 1. Order dated page 22. Order dated 23/9/22 for self-same cause of action. So they have given me no objection, my lord, for filing this writ. So this may kindly be recorded, my lord. It is my first prayer, my lord. Next is, my lord.
No, you've given the tabular column. On the right side of the column, whatever you want to record,
I want to record, my lord, my submissions.
But is that a ground for review?
Review, my lord, without these submissions, I can't go to the Supreme Court, my lord. I mean, told it has to be recorded. Otherwise, it will be told that I have not placed it before my lords. The reviews of I have to record my submissions. No new point can be taken there. That they have told me.
No. The employer gave no objection to filing the writ petition. They are not people who can confer jurisdiction on the court.
No. It was in order, it was in order. Please see the order dated 23/9/2022, my lord. Page can 1, page 22, my lord.
Can 1, page 22.
22, my lord. It's in order, my lord. It's recorded in order.
Can is not there. Only this is there.
But can has to be there. No, without can and without other, how can I show the papers?
In the cost list also, it is not there.
That's why this happened, my lord, because there are 12 or
No.
14 affidavits given by them. I have given 18 affidavits. There are hundreds of points, my lord. So unless the
All
points
right,
I know, how can I
You
record it?
approach the department, let them put up the CAN application.
And put on the whole file. Huh? It is filed in MAT number 2362 on 8/12/20. Not only this CAN, there will be other affidavits also. Sir will ask for the total file is required, my lord.
Oh, you want the main file to be brought?
Main file. Otherwise, how, my lord, my submissions can be recorded? I just want my submissions.
No, we thought you filed a CAN application in review. No.
I'll have to file a CAN.
No. Have you filed this?
No, I'm not filing.
So you want that record to be brought in?
Yes, my lord.
All right. We have heard the applicant, petitioner, appearing in person, and Mr. Vikas Chandra Bhattacharya, learned senior advocate, assisted by Mr. So-and-so, appearing for the respondent. The applicant seeks to rely upon certain documents which are not annexed to the review application, but he seeks to refer to the documents which were annexed in the appeal, namely MAT 2362 of 2023, and the documents annexed in various CAN applications filed in the said appeal. Registry is directed to trace out the appeal file, namely the appeal in MAT 2362 of 2023, and put up the same along with this review application. 3 weeks. Next.
I'm obliged, my lord.
Item number 10.
In this matter, what I propose to do, my lord, that I will just stick to the, my lord, the interpretation.
It is very short. I can't.
That is why I'm saying, my lord, what I'm submitting, my lord, that I will not refer to any judgments and all. Only the why my item is classifiable under 63 on the basis of bare perusal of that entry.
You are only concerned about your part of the story.
Correct.
They will make submissions, and who's to author the judgment? You imagine now we are on 3rd of September. 4th is one working day, 5th is holiday. 1, 2, 3, 4, 5. I've got exactly 5 more days to go.
And
I've got
I will conclude my submissions today.
You may conclude.
Yes, my lord.
But will you not understand the difficulty of one person sitting in the bench? Never ever I've shirked responsibility.
No, my lord.
Never ever I don't want to leave anything unfinished. I've reserved judgment yesterday. We have reserved. We will deliver that judgment. I am not accustomed to doing. When I got transferred from there was only one matter. I prepared the judgment. Could not be delivered because notification came. Mr. Agarwala appeared in that.
I understand, my lord. What I'm requesting, my lord, that perhaps, my lord, if I stick to the bare perusal of the act, my lord, your lordship will not have to reserve the judgment. If I don't refer to the elaborate arguments on the...
That you will decide whether to dictate in open court or reserve.
That is your lordship's discretion, but if your lordship allows me for 10
minutes... It can't be done, sir. It can't be done. Otherwise, why speaking for myself, I am not accustomed to... I am ready to face any challenge. 1 year and 2.5 months, we heard Birla Lodha.
Yes.
Within 60 days, we passed the judgment. How many years? 1 year and 2 months. 14 judges recused the man.
No, I know about that matter. Your lordship heard, my lord. Almost all the, my lord, advocates of the country appeared before your lordship. I mean, there was no big council left.
Everybody appeared.
On the either side, my lord, somebody or other appeared.
So you take your chance.
And your lordship.
We'll stop with this. The original side is there.
Then, my lord, kindly fix a date for this matter.
After vacation.
After
vacation, my lord is not there. Then we will decide the matter.
Let the matter adjourn. No. Mr. Vinay Sharaf, learned advocate appearing for the appellant, I would submit that that he will confine his submissions to and he will complete his submissions within a short time, and request the court to consider taking up the matter for final hearing. The learned advocate appearing for the respondents also have to be heard. It is no doubt that the other division bench, to which one of us was a party, my name, heard the matter at length. However, considering the fact that one of us, my name, is to retire shortly, the matter cannot be heard and judgment cannot be delivered within the date of superannuation. Therefore, the matter stands released from the list and papers be placed before the Chief Justice for appropriate orders. You take signature, ask Samra to place it, I will assign. I will assign it so that you get a date. Once it is assigned, it will come next week also. In September, it will come. It will come. Grateful.
I understood that one. But as Penny can go through this, the larger will decision of the Supreme Court. Exactly what you said is contrary to that one. But I'm not pressing anything.
Yes, Kuni Ahmed, we know. Thereafter, this was clarified.
Yes, and that was larger bench decision is there. Then every dismissal in limine should be treated as a binding decision.
Of course, Kodai Distilleries has explained.
I know, order is perfect. I'm not disputing. I'm handled because there is even after that there is judgment is there.
No, Mr. Sen has raised the objection. You argue.
I know that is there. But you are trying that I was suppressing. Why should I know the law?
Ignore it, sir. So many things you shouldn't take it.
That is
something should pass from this year to that year.
No, because I know because I also follow the latest judgment. That's why I try to educate myself only, not to.
One request, kindly keep it after vacation. Don't assign it as of now.
It won't come. It won't come.
No, I'm just requesting not to.
I can't say more than that.
Right.
This is in your interest.
Grateful.
Their interest as well. One more matter is there. Item 11.
Item number 11, man, I am for the appellant.
Hearing matter.
11, 12. But man, the matter is short. This is regarding matter change of opinion.
After vacation.
After vacation. But there is a stay, there is a demand staring at us.
Stayed.
There is a demand staring at us. That's the whole difficulty. But I believe, my lord, Mr. Dutt is the
appeal, my lord. Honorable Court has directed to participate in the proceeding.
Yes. Yeah, that is there.
Has been
But if you recover, appeal will become infructuous.
The appeal was dismissed for default once. Then it was restored. So thereafter, the interim order went. Previously,
then
there
we'll
was
do one thing. We'll list it after vacation.
Yes.
Give them an interim product during Puja. During Puja, if you do something, they'll become.
There was an interim order subsisting, my lord, before the.
And it is a hospital.
It's a hospital.
And what is the demand? Service tax?
No, income tax, my lord. Income tax.
Income tax.
But the whole issue is that, my lord, the pathological and the, my lord, this imaging center, diagnostic center cannot be part of hospital. Therefore, reductions under section 80 IB is not available. That's the issue.
That is wrong.
That is wrong. Absolutely wrong.
EOS interpreted his own law.
And what happened to your writ petition? Dismissed?
Dismissed.
Sir, show
No,
the
the
order.
writ petition was not dismissed. It was said that they have come prematurely. They should participate in the procedure.
There are two orders. I must tell you, Lordship. Subsequent, we came at the stage when, my lord, the recorded reasons were supplied. Thereafter, my lord, we already had registered our objections in terms of, my lord, GK and drive shaft. The objections, my lord, the recorded reasons, or the objection, the order disposing of objections is at variance with the recorded reasons.
No, where is the impugned order?
My lord, the
item number 12, that is MAC 616, that is at page 135.
135.
616.
Your lordship is looking at item number 11, that is MAC
615.
115.
Kindly take, my lord, page 135. of
615.
616. Well, both the matters were for 2 assessment years. Matt, my lord, 615, it is 130.
187.
187.
615 is 187.
But this is 135.
This is 616.
Yes, yes.
This is the second matter.
It's second matter. They actually told
Same.
you what are that? What are that?
Let there be an order of limited stay, and we shall come back before after the decision.
But this is change of opinion beyond 4 years, madam. ठीक है था your share. Where is the order disposing of objections?
163.
163.
163.
So the single bench directed opportunity to be given.
Yes.
Now, where is the order?
Disposing of objection. That is at 163 of this my lord, mat number 616.
No, it is not in this mat.
Lordship, kindly
You are shuttling from here and there.
No, no.
We have
I'm sorry, my lord. It is mat 616. Kindly take, my lord, page 163. This is the order regarding assumption of jurisdiction under 147.
Now, this was challenged by the second writ petition.
No. My lord, this order was, my lord, passed subsequent to the filing of writ petition. Subsequent to the before the matter was heard before the honorable single judge.
No, the learned single judge has remanded the matter.
Learned single judge remanded the matter, but this order was passed. Kindly take the date of the order. It is
18/5/2018.
18/5/2018.
What is the date of the single bench order?
Yes, just thereafter. 3/5/20.
But why you did not bring it to the notice of the single bench? You could have filed a supplementary affidavit.
We could not have. The writ petition was disposed prior to the.
That is what I am asking.
Yes.
Writ petition was disposed of
prior to passing of this order.
3/5/2018.
3/5/2018, and this is 18.
Did you not challenge this?
The honorable division bench gave us leave to file a supplementary affidavit disclosing this order.
That is wrong, sir. You should have withdrawn the appeal, challenged it by way of.
Your lordship, this is a long pending matter.
All right. Now, in the supplementary affidavit, they have filed the affidavit in opposition.
No.
Recently, it has been served.
No. Supplementary affidavit, disclosing the.
Now, where is the supplementary affidavit?
There is another supplementary affidavit now served.
এখানে annex করেছো কোথায়? Paper book এলো কি করে এটা? Because this is what?
28th August they have filed a supplementary.
Paper book টা তো
So the paper book was
ম্যাটের paper book এটা এলো কি করে? Supplementary affidavit মারতে এসেছিল।
No, you missed the bus. No assessment order has been passed.
The assessment order was passed, but there was a stay. The stay was that I will participate in the proceedings. They may pass the order, but they will not give effect to the order.
On what date that stay was granted?
But that stay was granted on 14/8/2018, which your lordship will find at page 173 of MAT 616. This interim order was vacated when the matter was dismissed for default.
Oh.
That is what has happened in this matter.
170?
173. (175) last paragraph, your lordship will find the operative part of the order.
You should have asked for restoration of the interim order when the appeal was restored.
When the appeal was restored, prayer was made for restoration of interim order.
Was it rejected?
it was rejected. Well, I have to be, whatever is there, I must tell your lordship. It was rejected.
Where is the rejection order?
Now Justice Manthar order to the
My lord had the restoration order was passed by my lord.
Then what you can do is,
yes,
protectively,
yes,
you file an appeal before the Commission of Appeals. Let it be pending.
Right.
This matter will come after vacation, you argue. That liberty will grant.
Yes, my lord.
Because in the event you fail in your attempt to get
But
the
this period would stand excluded, my lord. If I fail, suppose, my lord, I'm putting the question to myself with all humility, my lord. If this appeal fails, my lord, the period which is spent here.
It will be difficult because interim order is not there. If interim order was there, there's no problem. Otherwise, he will not condone the delay. We will direct that within 60 days from the date of receipt of a copy of our order.
Yes.
You file the appeal.
Without prejudice to our rights in
Yes. And the appeal shall be taken on record and kept pending and await the decision in the matter.
That we will do. That
will be better.
That will be better.
And in the meantime, don't enforce.
I would only request my learned friends that, my lord, this is not that kind of matter which we usually
and
do.
What according to the officer that you did not disclose which information?
My lord, there is no question of non-disclosure. I tell you, lordship, what has happened. First, the question is that this diagnostic clinic cannot be part of the hospital. This was the ground on which, my lord, reopening was initiated. Then, my lord, in the reasoned order disposing of the objections, my lord, the grounds on which the reasoned order was passed is at variance with the reasons recorded in the and 148 order for assumption of jurisdiction. Then what happened when the assessment order was passed? My lord, all those reasons now are given a go by. Now, and further reasons are being given, my lord, which is, my lord, this would be squarely hit by Sun Engineering, because this is not the new regime matter. This is an old regime matter.
All right. These appeals have been listed for hearing. For want of time, the matter cannot be taken up. Though initially the appellant had an interim order granted by the division bench dated 14/8/2018, by which the division bench directed the assessment/reassessment proceedings against the appellant may continue, but the respondents will not enforce any demand against them till the disposal of the appeal. The appeal was dismissed for non-prosecution. Consequently, the interim order also stood vacated. Subsequently, application was filed to restore the appeal, and the appeal was restored, but the interim order was not extended. In the present circumstances, the learned senior advocate appearing for the appellant submits that their client apprehends that recovery proceedings may be initiated by the respondent department, since already assessment order has been passed. It is to be noted that after the disposal of the writ petition by the learned single bench on 18/5/2018, the objections raised to the reopening proceedings was disposed of. Thereafter, assessment order has also been passed. Both these orders have been put to challenge in this appeal by way of a supplementary affidavit, copy of which has been filed today. And the same has also been served on the learned advocate appearing for the respondent department. Liberty is granted to the respondent department to file their affidavit in opposition if they so desire. Since the appeal is pending and there are no order of stay, we direct the appellant, without prejudice to the rights and contentions of this appeal, to file a statutory appeal before the Commission of Income Tax (appeals), having jurisdiction over the assessee. And if such appeal is filed within a period of 60 days from the date, 30 days from the date of receipt of the server copy of this order, the appellate authority shall entertain the appeal and keep the appeal pending and await the decision in these appeals, namely MAT 615 of 2018 and 616 of 2018. List the matter.
Well, only one submission, my lord. If your lordship kindly takes your lordship's order. Last paragraph.
In assessment order is of 2018.
Yes, yes.
Similarly, we have not taken any steps, we will not take any
Your lordship was pleased to record that if there is an.
So we gave liberty.
Yes, yes, yes. Yes.
And have you pleaded for interim order?
in the no.
Senior is looking at you, Mr. Ananda Sen. You are looking at your junior, and he will look outside the window.
I'm
This is not the way.
No.
I'm extremely sorry.
In this supplementary affidavit, what is your prayer?
What is your
No prayer.
You people are not vigilant, and then you will start blaming the court.
No prayer. Lord, only pertaining to your kind lordship, kind leave given, we have only brought the assessment order, reassessment order on record by.
He said that liberty is also granted for.
Yes. That liberty was given.
Then, since sir asked them to open this, while
Application is pending or exposed.
that order is there in this order, Udayan, this copy will be here, no?
Order copy. No, not here. Order copy
Order sheet is not there.
Where clear. Order sheet of our discord. No,
By order dated.
no, but that after dismissal order.
After the in the order dated 31/7/2025, while permitting the appellant to file supplementary affidavit, liberty was also granted to pray for appropriate interim orders. In the event there is any coercive action initiated by the respondent department for recovery of the taxes. Though such liberty was granted, the appellant has not filed an application for appropriate interim orders. The learned senior advocate appearing for the appellant submits that the appellant will file an application at the earliest and the same may be considered. Leave granted to file appropriate application for appropriate interim orders. And if such application is filed, then let the same be listed before this court.
So grateful to your lordship.
As and when the same is filed. You file an appeal, statutory appeal, the appeal will be kept.
I think that will be a protective appeal, ma'am.
That will be a protective appeal without prejudice to your right.
Because that will secure.
Then you file a stay application. We are here to advise this.
No, this is so embarrassing.
No embarrassment.
Since the appeal is pending, I shall instruct the department not to proceed.
You tell them, and they are also filing a stay application.
Yes.
For the supplement. See, basically they say, you go into that 80 IA, no?
Yes. I see. IV 11C. 6.
See, if it is integral part of the hospital, like captive power plants, we have held in so many matters. Recently also we did one matter. So that is the test. But what they say is, your order disposing of the objections is on a different ground. Assessment order is
another ground.
And that is on the merits of the matter, but the appeal is pending, so I shall instruct them.
The hospital now statutorily requires to have a diagnostic center. Because it is not a complete medical establishment or a clinical establishment.
You would have availed duty exemption when you imported the equipment.
Yes.
Correct?
Must have. That instruction I have to take, man. That instruction.
90% of the cases, violation of the condition.
Right.
And show cause notices were issued, etc. I defended the department in that matter. We were successful up to Supreme Court. Then second round started. Supreme Court remanded the matter. The first assessee was Apollo Hospital.
Right.
Where I think 25% of the patients have to be given free treatment. And all of you fudged the records. That investigation was done.
We did not take that.
They got caught. Then Supreme Court remanded the matter.
Yes.
Unfortunately, it landed before me, sitting single. Then I said, I'll recuse. No, they said, no, you hear. I heard. I did something against them, I think. Matter went to division bench. Unsuccessful, went to SLP. There they got one small liberty and came back. Unfortunately, once again in the division bench, it came before me. Ultimately, they had to pay up. Total exemption.
That's a non-fulfillment of the condition of the exemption.
All right.
Grateful, my lord.
Next. Original side.
Original side daily list item number
Your
1.
Lordship, I crave leave to mention, Your Lordship, that CAB matter, that matters come down in the list to item
Out of
131.
the list.
But that matter will not take too much of time. My written notes are also ready, Your Lordship.
Whatever we told for this Vinay Sharaf.
My Lord, I'm grateful, Your Lordship. I'm grateful.
Yes, item 1. How many days?
Item 1, my lord, we have been served with a bunch of papers, my lord, relied on by the
delay is condoned also.
No, delay has to be condoned. There's a delay of 124 days.
Right. Delay condoned, sir. Satisfied reason, so and so. And compilation has been received.
Yes,
The
yes, yes.
tribunal's order refers to the paper book used before it, so I thought it better
All
to
right.
provide it to my
The learned advocate appearing for the assessee has filed a compilation containing the documents which were placed before the learned tribunal. Copy of which has been served on the learned advocate for the appellant. The same is taken on record. Next.
Oblige, my lord.
Oblige.
For admission of tax matters item number 2.
May it please your lordship. The delay was condoned on the last occasion. This is the original assessment. Thereafter, it was reopened. Then 263 jurisdiction was exercised. Then your lordship would straightway come to the tribunal's finding. I will not travel, your lordship, because I am not convinced with this.
Page 115.
Yes, I am showing that, your lordship.
We start with 110, 115.
Yes, madam. Addition was made on the basis of the fact that these are the sale companies, but apart from that finding of the assessing officer, let me be very candid to your lordship, there are no other facts which matches the contents of the assessing officer.
At 125.
Paragraph 13.
order is very confusing. At one point he says this, that, assessee is not done that. Yeah.
But what the tribunal is saying, that there was an original assessment, it was sent back, commissioner gave certain directions, that those directions have not been complied with. So since the matter,
But before the AO, they have produced all the evidence.
originally.
Original.
That is the original.
And then what the summons were issued without mentioning the name of any director. There were 4 directors. So they gave those details. There are no specific.
They are satisfied.
There were no specific summons.
This is
were
the appeal by the revenue filed under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated October 16, 2024 passed by the Income Tax Appellate Tribunal A Bench Calcutta Tribunal within bracket in ITA number 986/KOL/2024 for the assessment year 2008-9. The revenue has raised the following substantial questions of law for consideration. Page 5 of the stay application. Question number A. C. D. F. We have heard so. The issue which calls for consideration was whether the learned tribunal was correct in allowing the assessee's appeal, challenging the order passed by the Commission of Income Tax within bracket appeals, NFAC Delhi, dated 15/3/2024, arising out of an assessment order framed under section 144 read with section 263 of the Act by the Income Tax Officer, Ward 6 within bracket 2, Kolkata, dated 19/3/2014. In the initial scrutiny assessment, no, that was a 143(1), is it?
143(3)/147. It's a reopened assessment. In which
Reopened assessment.
It was reopened.
That assessment order they have enclosed?
Yes.
Yes, ma'am, which is at page.
Page 11.
Page 11. The first annex.
Sorry, what did he say? No, please strike out that. The return of income filed by the assessee was duly processed under section 143 within bracket 1 of the Act. Subsequently, the assessment was reopened and completed under section 143 within bracket 3, read with section 147 of the Act by order dated 12/5/2010. The against that order, you filed an appeal before Commissioner Appeals. No.
No.
That order was in
That order was revised under section 2.
the said order ensued in favor of the respondent assessee. The Principal Commissioner of Income Tax within bracket PCIT exercise its jurisdiction under section 263 of the Act. That order is not here.
Yes,
page 14.
That very next page. Page 14 of the Lordship's bill.
At page 19 is the operative part.
263 of the Act, and an order came to be passed dated 30/3/2013.
Yes. Page 19.
By setting aside the assessment order and directing the assessing officer to examine the genuineness and source of share capital, not on a test check basis, but in respect of each and every shareholder by conducting independent inquiry, not through the assessee. The bank account for the entire period was directed to be examined to find out the money trail of the share capital. Full stop. The assessing officer was directed to examine the directors as well as examine the circumstances which necessitated the change in directorship, if applicable, and that he should examine them on oath to verify their credentials as director and reach a logical conclusion regarding the controlling interest. The assessing officer was further directed to examine the source of realization from the liquidation of assets shown in the balance sheet after the change of directors, if any. The direction issued by pursuant to that, the assessing officer completed the assessment by order dated 19/3/2014 under section 144 read with 263 of the Act. Agreed by such order, the assessee preferred appeal before the NFAC, which was dismissed by order dated 15/3/2024.
Yes. Page 30.
Challenging the said order, the assessee preferred appeal before the learned tribunal, which was allowed, and agreed by the same, the assessee, the revenues filed the present appeal. We have carefully examined the reasons assigned by the tribunal, more particularly from paragraph 14 of the impugned order. In paragraph 14, the learned tribunal has noted the submission made on behalf of the assessee by which they furnished a tabulated statement containing details about the directions issued by the PCIT and the action taken by the assessing officer and the remarks of the assessee. After noting the submissions made by the assessee, the tribunal proceeded to examine, in an elaborate fashion, the correctness of those submissions. And ultimately, the tribunal noted, and after taking note of the various decisions of the Honorable Supreme Court and this court, held that the assessing officer in the second round did not make any independent inquiry to verify the genuineness of the transaction, despite the assessee having furnished all details and documents. That apart, the assessing officer has not pointed out any discrepancy or insufficiency in the evidence and details furnished by the assessee. Therefore, the tribunal came to the conclusion that the assessee, having discharged the initial burden cast upon them to prove the identity and creditworthiness of the share subscribers and the genuineness of the transaction, the burden shifted to the department to examine the evidence furnished by conducting independent inquiry, and they are required to state on what account the assessing officer was not satisfied with the details and evidence furnished by the assessee, and the same should be put to the assessee. What is the citation of this corporation private limited, CIT versus corporation?
Ursa Corporation. But at page 127, if my lordship is 159 ITR, page 17, page 127 in the middle of that page.
No, they say apex court. It's not apex court.
Ursa is, no, it is Supreme Court. I have a copy of it.
Please show. Which paragraph the tribunal has quoted? It starts, in this case, the assessee had given.
Page 84.
Yes. The learned tribunal took note of the decision of the Honorable Supreme Court in the case of Commission of Income Tax, Orissa versus Orissa Corporation Private Limited, 1986, volume 159 ITR, page 78. Wherein it was held that in the case where the assessee had given the names and addresses of the alleged creditors, and it was in the knowledge of the revenue that the said creditors were income tax assessee, the revenue, apart from issuing notices under section 131, at the instance of the assessee, did not pursue the matter further. The revenue did not examine the source of income of the alleged creditors to find out whether they were creditworthy, and that there was no effort made to pursue the so-called alleged creditor. Therefore, it was held that the assessee could not do anything further, and approved the finding of the learned tribunal that the assessee had discharged the burden that lay on it, then it could not be said that such a conclusion was unreasonable or perverse or based on no evidence. After taking note of the said decision, the learned tribunal also took note of the decision of this court in the case of Principal CIT versus Sri Leathers, 2022 448 ITR 332 within bracket Calcutta, and applied the decisions of the learned tribunal applied the law laid down in the decision, and pointed out that the assessee has successfully explained the nature and source of the alleged investments in share capital and share premium by proving the identity, genuineness and creditworthiness of all the 18 share applicants who are regularly assessed to income tax, their financial statements and were duly audited and passed through scrutiny proceedings by the income tax department, and they have sufficient net worth to explain the source of investment in the share capital and the share premium, and therefore held that no addition is warranted under section 68 of the Act. Thus, the tribunal has granted relief to the assessee upon thorough examination of the factual position, and we find no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, appeal stays rejected.
Item number 3.
Please, Your Lordship.
Some application you have filed.
Lord, the application was filed by my learned senior friend in the other side for expeditious hearing of my appeal. Your Lordship wanted us to, Lord, come ready with the appeal itself, Lord, and
we can't do it and everything.
Lordship kindly keeps it on Monday in that case.
Monday, no, after vacation. Hands are full.
my Lord, if it comments to Your Lordship, Lord, it be. I don't think it'll
You
take
already declined 2 matters.
But it will not take much time. I can assure
10
Your
to
Lordship.
15 minutes, Lord.
Your Lordship can spare my Lord 10 minutes. The matter can be disposed of.
I'll in a nutshell, Lord, I'll tell Your Lordship.
Now the gold bars have been released.
No.
That is
That's the appeal. Lord, they have confiscated it.
So imagine the rate in 2012. Now it has gone up.
Yes, and today if I win, Lord, I might get a little better. But and I'm sure, Lord, Your Lordship.
Application has been filed to expedite the hearing of the appeal, which pertains to an order which challenges an order passed by the learned tribunal in 2018. Considering the matter is a long pending matter, though the appeal had been filed only in 2024 by the revenue, by the assessor. Let the appeal be listed. for hearing on 12th November.
Before your lordship. I assure your lordship, my lord, on 4 documents the appeal can be over. I assure your lordship.
I am trained in such a way I can't stop like that. Once we get into it,
I understand, my
we
lord.
have
I
to
will see
take
your
it to the
lordship.
logical end. You may be satisfied and stop, but I will not be satisfied.
I'll tell your lordship, my lord, the only thing is whether it's of foreign origin or not.
Possible, I will definitely do another. Next.
Grateful.
This one, the paper books file out of time, maybe, my lord.
Yes, paper books shall be taken.
Look, 2 copies of paper.
Item number 4, my lord, pursuant to your lordship's earlier direction, we have tried to serve through the department, and the department went to the place, and wherein, my lord, the person, the SSC was not found.
It
We
has
had
been served.
conversation with the SSC, and the SSC said that the papers or the petitions may be given to one of its neighbor, and we have handed over to the neighbor.
And taken acknowledgement.
Yes, my lord, there is an acknowledgement. If your lordship kindly sees it, I have a copy of it. Kindly sees the last page. So there is a application for condonation of delay of 142 days. 192 days.
192.
And who appeared for the SSC before the
Mr. Nirmal Chaudhary. We have tried to serve upon him, but Mr. Chaudhary said that the client has no he has no connection with the client any further. If your lordship directs, I shall serve upon him one more time and come back.
Yes, come.
ট্রাইব্যুনালে আমরা আপনি জিতেছেন আমরা এখানে এসেছি
Client has no connection with us. Where he's staying, he's not there. Our telephone is not taking. His wife used to come. He's not picking up. What can I do? No instruction.
Where are your substantial questions?
Those are at page
27.
27.
According to the tribunal, it was barred by limitation, is it? We have heard Mr. Kaushik Delan and Senior Standing Counsel for the appellant revenue. In terms of the earlier direction, the department has taken steps to serve notice on the respondent. When the officer of the department personally went to serve notice, the premises was found to be locked. And the officer contacted the assessee in the phone number given, and he was advised to hand over the notice to the neighbor, Mr. Subir Kumar Banerjee. Accordingly, the notice was handed over, and an acknowledgement has also been obtained from the said person. Till date, the respondent assessee has not engaged any advocate in the matter. There is a delay of 192 days in filing the appeal. As the delay has been properly explained, the same is condoned. Application in GA 1 of 2025 is allowed.
Right.
Now, the next para, the appeal is admitted on the following substantial questions of law. Page 27, question capital A, capital B. So capital B, you stop with this. Don't mention these figures. B. C. D. F and G. Then usual directions.
I can't stay because I have made an application for stay also, stay of the operation of the order passed by the learned tribunal.
What is the direction given? You see the penultimate paragraph?
Lordship kindly comes to para 14. Accordingly, the demand on account of denial of credit is
No,
set
it has
aside.
been set aside. Where is the question of stay?
One indulgence of my lord, the very next matter, that is item 3 of the combined monthly list.
Which next monthly list we are not taking?
Not taking up.